Hello and welcome to the Herrington Carmichael Employment Law Update for September 2018. My name's Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael, and as always I've got the 4 key developments in employment law in the last month to bring to you. This month they fall into 2 categories: the enforcement of post-termination restrictions and contracts, and employment tribunal process and procedure. Let's start with the contractual claims first. In the case of Brown and Neon, we see a situation where Mr. Brown resigned with 6 months' notice. By resigning with 6 months' notice, the High Court held that actually that affirmed the contract. He could have resigned and not served notice and effectively resigned with immediate effect, and in that circumstance would have been able to argue the contract was not enforceable. However, in this case, because the notice was properly given, it affirmed the contract, keeping the contract enforceable. May sound quite harsh, but nonetheless, where a contract is affirmed, it can mean the contract is still enforceable against the employee. This is a very case or fact sensitive situation, and each particular case will need to be looked at very carefully. The next case is Tennant and Corley. In Tennant and Corley we have a situation where Ms. Corley did not sign her contract of employment and Tennant tried to enforce it against her. They weren't able to get an injunction, so they weren't allowed the interim relief that is afforded by injunctive action. And in this case, amongst a number of findings, the judge reminded Tennant that they should have obtained a signed contract. There needs to be a proper affirmation or acceptance of post-termination restrictions. What's this mean for you? This means that if you've got contracts where an employee has not signed them, you need to take action about that, or you need to make sure that whenever an employee is joining your employment or being promoted, or there are changes that are taking place, that those are properly incorporated and there's a proper affirmation in relation to the new contract. Look at it carefully because you'll regret it later. Let's move on to tribunal practice and procedure. The first case here is the case of Meyer and Axis. In this case, Meyer served his employment tribunal claim form on the Friday. They put it in the post on the Friday, but it wasn't received by the employment tribunal until the Monday. However, the time limit in relation to it lapsed on the Sunday. The argument was that the time limit should automatically be extended over to the Monday. Wasn't held. Unfortunately, didn't work. Simply a not practical argument, and the case was out of time. Seems quite harsh, but the rules are strict. If there are time limits and they're going to lapse, you have to comply with them, which is why we always send stuff by email. Final case this time is the case of Office Equipment Systems and Hughes. In this case, Office Equipment Systems forgot to file the response form to the claim. Probably have heavy hearts sat there and, oh my goodness me, how did we miss that deadline? Ordinarily, when a response form is not filed, the respondent can no longer take part in the proceedings going forward. However, it was clarified that the respondent could still participate in the remedies section, so the value of the claims section, when the amount of remedy was determined. So that still gives some protection to employers where the response form date is missed. Obviously, best advice is not miss a date and file the response form, because then you can defend the claim on all grounds. However, in the unlikely circumstance that it were missed, there is still some protection. That's it from me this month. I'll be back with you in October, and until then, best of luck. Thank you.